Welcome to the virtual rebroadcast of PubCA's 2024 Government Contracts Annual Review. During this week, we are presenting 14 panel discussions featuring more than 70 expert practitioners, as well as 2 in-depth conversations with key government officials. PubCA publishes news and insights for the government contracts community, such as PubCA Protests and Claims, PubCA Cybersecurity and Data Privacy, and PubCA Compliance and Enforcement. In addition to our annual review, we also host webinars, podcasts, and in-person networking meetings during the year. If you'd like to learn more about PubCA, visit us online at pubcagroup.com. All of this week's presentations were recorded live at our in-person conference in February at the Ronald Reagan International Trade Center. You can join any or all of these sessions during the week using the same link and password you used today. All attendees will be in listen-only mode. Your video will remain disabled through the entire session. Many of our panelists are joining us today to answer questions about their presentations. Enter your question into the Q&A box at the bottom of your screen, and the panel will address as many as possible during the webinar. If time allows, we'll open up a live Q&A session after the video presentation. Our briefing book, which includes all of this week's slide presentations and other materials, are available for download from the PubCA website. We are applying for continuing legal education CLE approval in Virginia, California, Texas, Florida, Colorado, and Kansas. While we cannot guarantee approval, we expect acceptance within the next few weeks. We will notify all attendees when those approvals have been received. If you received CLEs for our in-person event, you can apply for additional CLEs for panels that you may have missed. And finally, if you are interested in obtaining CLE, please look for our poll question during the presentation. The state boards require us to verify your participation during the event. The poll is a simple yes/no question. We will keep track of all responses to verify that you viewed the panel. If you do not wish to obtain CLE credit, you can disregard the poll. This conference would not have been possible without the strong support of our event sponsors, all of whom are listed on the next few slides. Our sponsors also provided speakers for our event and other valuable input. We encourage you to review the strengths and capabilities of these firms and to reach out to them directly with any questions you may have. And now we present our next panel, the False Claims Act.
Live and in person, this is really quite an impressive showing. As I think somebody else had said, it was really nice during the years of the Thomson West year in review to see everybody annually, and so this is a spectacular turnout for the first in-person PubCA annual review. I'm Andy Liu, and I'm going to be helping to moderate today's panel. I'm a partner with Nichols Liu, which is a government contracts law firm here in Washington, D.C., and I chair the firm's disputes and enforcement group, and my practice focuses, just as my co-panelist does, on False Claims Act, litigation, and investigations. So we have a terrific panel of experts on False Claims Act today. I'm going to briefly introduce each of them. To my immediate right is Tirza Lawler, who's a partner at Arnold & Porter, where she co-chairs the firm's False Claims Act practice, and her practice focuses on white-collar defense, internal and government investigations, and trial work. And to her right is Ann Robinson, who is a partner at Latham & Watkins in its white-collar defense and investigations and complex commercial litigation practices. And she focuses on representing government contractors in FCA matters and other areas. And last but not least is Jonathan Phillips, who most right, exactly, who is a partner at Gibson Dunn, where he is a member of the firm's litigation department and co-chairs its FDA and healthcare practice group and its False Claims Act practice group. So as usual, for those of you who have participated in this annual review online in past years, This panel is going to cover the most notable case developments from the past year, talk a little bit about DOJ guidance and policy matters, and time permitting, we'll cover the trends and where we see DOJ's enforcement priorities. So with that, I'm going to turn this over to Anne, who is going to kick us off with a brief overview of the FCA. And I should note, these next slides are not in the written materials, but we decided that, given the size of this audience, maybe not everybody was intimately familiar with the basics of the FCA, so we added a few slides in for that.
Great, thank you. So just to start out with the overview of this statute, the False Claims, I feel like I'm about to make a really not desirable noise. Okay, thank you. The FCA imposes liability on any person who submits a claim to the federal government that he or she knows or should know is false. One of the important features of the False Claims Act is there is a whistleblower provision, which means that a False Claims Act case can be initiated either by the government or by a private plaintiff known as the qui tam relator, and the relators can receive up to 30% of the recovery plus attorney's fees. So there is a big carrot out there to file these cases. These cases are very unique procedurally. If you're a defendant in a False Claims Act case, you don't get served with a complaint immediately. Rather, these cases by statute should be filed under seal, and that permits the government a period of time to investigate the case. So typically when you're a defendant, you receive notice of the case by receiving a subpoena called the Civil Investigative Demands, and that alerts you that there's an FCA investigation into your company. And DOJ has broad investigatory powers in issuing these CIDs. They can require the production of written documents, oral testimony, written interrogatories, and that investigation period can take months and sometimes many, many years for the Department of Justice to complete. At the end of that period, the government decides whether to intervene or join in the case. And it is only at that point that the case becomes public, once the government files its notice of intervention. And the relator then, even if the government declines to intervene, can still decide to pursue the case, and then you enter federal litigation if you're not going to settle the case at that point. So the elements of an FCA claim are, and the violation entails the knowing presentation or submission of a false or fraudulent claim that is material to payment. The scienter element, the first element in a False Claims Act claim, is fairly low for liability. Sarah mentioned this earlier, but reckless disregard, which is akin to gross negligence, is enough. So you have kind of this very low scienter in the statute. However, there is case law that does stress that the mere breach of contract does not rise to the level of a False Claims Act case. You have to have some sort of fraud in order for it to qualify. And the other very important aspect about the statute is that there's treble damages and penalties. So the money involved in these cases can mount very, very quickly, because you have the actual damages that get calculated. The government oftentimes takes the position that's the entire value of the contract. And then that amount by statute, if you took a False Claims Act case all the way to a verdict, has to be trebled. And then there's a penalty component that has to be applied. And currently it's $27,000 is the maximum, and that's per false claim or false statement admitted and submitted, and those can mount up very quickly as well.
Thank you very much. Okay, so we're next going to just talk about statistics real briefly. Tirzah?
Sure, thanks Andy. So we are all eagerly awaiting DOJ's press release announcing its fiscal year 2023 FCA recoveries. Usually they've come out by Valentine's Day, so maybe we'll get something tomorrow morning as a Valentine's Day gift from DOJ. But so what we've got on this graph here, the lines 2009 to 2022, those are the recoveries that DOJ has reported in past years. The number for 2023, That's based on information from Arnold and Porter's Keynotes blog, where we track recoveries throughout the year. And then at the end of the year, we get to see how well we did. The important thing is that, for those of you that may not be quite as familiar with the False Claims Act, is that, these numbers are huge. These are not in the millions, they're in the billions with a B. Total amounts that DOJ recovers every year through False Claims Act settlements or litigation, trial outcomes. These include both cases that are brought by relators and those that DOJ brings itself, So on average, I think it works out to about between $3 and $3.5 billion per year in FCA recoveries. I know there's a panel that's going to talk about the FCPA tomorrow and sanctions enforcement. I think the FCA enforcement dwarfs what we've seen in those types of cases. If we could go to the next slide. And then we just have a quick slide here in terms of the breakdown. So where do these dollars come from? The vast majority comes from the healthcare industry, so not very interesting to the folks in this room here. A much smaller proportion would come from the defense industry, so that's any DoD contractors, and then we've got kind of an other mishmash, miscellaneous bucket. I will say that for 2023, the number, even though defense and other are dwarfed by the healthcare recoveries, for 2022, the healthcare piece was a much larger section of the pie. It was $2.3 billion in recoveries in the healthcare industry, where DoD was only $60 million and other was only $8 million. So even though, the defense slice is a little bit larger for 2023, typically it's even smaller than that. But for anyone in this room who has found themselves on the tail end of a FCA investigation or litigation, that's probably small comfort because of everything that Ann was saying in terms of treble damages and significant penalties.
Can I add just one thing to that? I think if you look at the recoveries leading up to 2022, it's really been about 80 to 90%, right, of the recoveries in terms of dollar amounts have been in the healthcare. But given just the sheer magnitude of the numbers here, we're still talking in terms of non-healthcare cases, like 400 cases filed a year, right? Mm-hmm. And $500 million a year. I remember back when I first started speaking about the False Claims Act in the 90s, like $600 million for the recoveries was just astronomical. So we're still talking big dollars, right?
Absolutely. Absolutely.
Okay, next we're going to talk a little bit about case law. So this past year we saw 2 Supreme Court cases involving the False Claims Act. And so I think Jonathan is going to talk about the first one.
All right. Whoa. All right, so if anybody attended the excellent panel on cybersecurity and is using that as a benchmark, I want you to know what you're looking at is a live view of FCA case law. The first case we're going to cover here is U.S. Ex Rel. Polanski against Executive Health Resources. This dealt with the government's power to dismiss qui tam cases over the objections of the relator who brought the case. And this comes from a statutory provision in the qui tam part of the statute, which states that the government may dismiss the qui tam action notwithstanding those objections, provided the relator has notice and an opportunity to be heard. A note on why this matters, just jumping off of the statistics we just heard. In addition to those statistics about the dollars that are at stake, what we also see year after year after year, and what I expect to see when we get our Valentine's Day present of the 2023 statistics, is a record number of cases being broken every year, which, for you and your companies, that has, often as much or more impact than looking at the judgments and settlements out there, because that's a cost that you have to deal with in terms of litigation and reputational risk and dealing with your partners in government and giving them comfort that notwithstanding this qui tam case, whatever the merits, you're a good business partner and so on. We also see, the resources that are being brought by the relators bar to these cases to litigate them after the government has declined are getting better and better. There's litigation funding, an investment in these cases, More of these cases are being taken into litigation after the government declines, even in cases that seem to have very little and maybe no merit on their face. So I think it's fair to ask, shouldn't this power that the government has be used to avoid from a big picture perspective, the waste of having to litigate cases that are non-meritorious? That is a question that industry was really raising the alarm about in kind of the mid to late 2000s into the early 2010s, and but notwithstanding that, up to the Trump administration, the Department of Justice had only utilized this power approximately 50 times in the entire history of the statute, which goes back to the Civil War. During the Trump administration, there was an initiative to encourage trial attorneys at the time that they were getting authority to decline, consider whether it was also appropriate to utilize this power to move to dismiss. And it resulted in what you see on the slide, a series of criteria that are now codified, so to speak, in the Justice Manual, telling line attorneys, here are the factors to consider about whether this case is appropriate to move to dismiss. And there's a variety of factors there listed on the slides. Since that time, there are approximately another 50 or so we've roughly doubled the number of cases in which the government has moved to dismiss, over the objections of the relator. If you look at the rationale that the government has set forth in those cases, although there are many possible justifications, all of which come from real examples of past cases. What these cases overwhelmingly come down to is, does the government think is going to expend substantially more resources in discovery and in litigating the case, even as a third party, compared to the potential benefit, taking into account the merit or potential lack thereof. So that's the backdrop. So let's look at the case. So in this case, the actual allegations are not particularly important. It was an allegation of billing medically unnecessary health services to government health programs. The government, after the government declined, it was actually litigated for several years. The relator invested substantial resources in the case, and eventually the government came in and moved to dismiss. Made its way up to the Supreme Court, who was asked to resolve a circuit split around what is the standard a court should use in evaluating the government's request to dismiss. And there had been a sort of three-way circuit split that had developed, all of which really deferred to the government to some extent. But on certiorari, the relator's bar argued really none of those standards should be used, and the government should never be able to come in and utilize this C2A authority after it has declined to intervene. The Supreme Court disagreed. It affirmed the lower court grant of the dismissal, and the standard it took up in an 8-1 decision, at least among the 8 justices that joined the majority, was the government's decision to move to dismiss is subject to the same evaluative process as a Rule 41 voluntary dismissal under the federal rules of civil procedure. So all the government has to do is intervene in the case, which it can do for good cause. It's a low bar. And then the court evaluates a Rule 41 dismissal. Maybe the most, and the court said that should be given substantial deference. And in fact, the court went so far to say it is a very, very rare case in which the government's decision to move to dismiss should be second-guessed by the district court. I think probably the most unusual part about that case is that it was 8-1 and not 9-0. Virtually every False Claims Act case that has gone to the Supreme Court in the past few decades has been a 9-0 decision. This one was 8-1. And what was more interesting, I think, about the opinion in this case was the one dissent by Justice Thomas, which Terza will talk about now.
Jonathan, you stole my thunder. I was going to lead with that. You're exactly right. So Escobar was unanimous. The KBR statute of limitations case in 2015, that was actually our case, that was unanimous. Schuette, which you're going to talk about in a minute, was also unanimous. But this one was not, and it's because that Justice Thomas dissented, arguing that the case should have been remanded for consideration of whether the qui tam provisions, these whistleblower provisions that allow a private relator to sue in the name of the United States, are unconstitutional. And it wasn't just one justice. I believe we heard a little preview about this morning, but Justices Barrett and Kavanaugh, in a concurrence, agreed with Justice Thomas's constitutionality concerns, and the Chief Justice, during oral argument, made some comments suggesting that he also had some concerns about the constitutionality of the qui tam provisions. Does anybody know how many 4 justices are needed to vote? Does anyone know how many justices are needed to vote to grant cert for the Supreme Court to take up a case? Right, it's 4. And in fact, Justices Roberts, Kavanaugh, and Barrett are the justices most often in the majority. So what exactly is the argument? So I think what Justice Thomas grabbed onto in his dissent was that under the Appointments Clause of Article 2 of the Constitution, that representation of the United States interests is an executive function that may be discharged only by persons who are officers of the United States. And obviously, all these little private relators that are running around, disgruntled former employees, I shouldn't denigrate, but you know which side I'm on this.
Some courts have called them parasites.
I would not disagree with a federal judge. So anyways, that the qui tam provisions violate the Appointments Clause. I think there's also a concern that the qui tam provisions violate the Take Care Clause. That's Article 2, Section 3, that the executive branch's responsibility it is to take care that the federal laws are faithfully executed. So in our view, it's really not a question of when the Supreme Court is going to take up not if the Supreme Court is going to take up this question, but when. So we have seen, if we go to the next slide, there have been a handful of constitutional challenges filed to the qui tam provisions so far. Frankly, I don't understand why we haven't seen more of these. You don't need to necessarily raise this issue with your first 12B1, 12B6 motion. What we've seen in these cases is that another alternative vehicle is to file a 12C motion for judgment on the pleadings. And there your concern just needs to be that you would not be potentially delaying trial by filing the motion. So what we've done in a couple of our cases for some of our A&P clients is if a relator has gotten past the initial 12B, 12B6, 12B1 motion, then at that point we would file the 12C motion. So far, not a lot of traction at the district courts. I can tell you the Planned Parenthood case, that's one of our cases. The decision is under seal, but let's just say that the constitutionality challenge was not successful. The one on the bottom, that's our case. It was just recently fully briefed. DOJ, unsurprisingly, filed a statement of interest arguing that, of course, the qui tam provisions are consistent with the Constitution. I think TAF, whatever it's called now, also filed an amicus brief. On behalf of our client, Floor, we were able to get support from the Chamber of Commerce to file an amicus, which is pretty rare to get at the district court level. So that brief, that motion is fully briefed, so we'll be waiting to see what happened. Before kind of this whole thing with Justice Thomas's dissent breathed new life into this potential constitutional challenge, there had been some rumblings before. Former Attorney General Bill Barr, back when he was just an AAG, had written a memo advocating that the Justice Department take the position that the qui tam provisions violate Article 2. Then perhaps unsurprisingly, when he was at his confirmation hearings under questioning from Senator Grassley, he backtracked and of course said, no, I think the qui tam provisions are constitutional. There are some court cases. There was a Fifth Circuit case back in 2001 where the court struck down a constitutionality challenge. But I think even back then there were 2 dissenting judges. So the Fifth Circuit is maybe a circuit that would be potentially ripe for being interested in such an argument. So I guess if you take anything away from the conference, I guess I would suggest that if you're litigating a non-intervened case, you need to think about when the right time is to file one of these challenges, because I do think that eventually the court's going to take it up, even if it means it will impact outside counsel's business development planning.
Let me make one additional kind of comment, I guess, about C2A. So I think that, the constitutional issue is super interesting, right? On the principal issue before the court in this case, I don't find that interesting, because no matter which of the three standards they were trying to push for in terms of the standard for the government to dismiss a case over the relator's objection, I think the government can satisfy. To me, the more interesting issue is when and how do you get DOJ to actually exercise its authority under C2A a little bit more often. I think it's especially kind of pertinent to the folks in this room, because as most of you probably know, the cost of defending a False Claims Act suit, if you end up settling it or losing liability, the cost of defending the suit are unallowable costs. But if you prevail, if the case does not proceed, if you don't pay a penny, those costs are allowable costs that then get kind of baked into your overhead rates and get passed on to the taxpayers. And so to me, kind of the whole purpose of the False Claims Act is to protect the public fisc, and dismissing meritless cases, kind of advances the purpose of the FCA. But we still see so few truly meritless cases being dismissed by the Department of Justice.
Right. Just one other point. Since the Polanski decision that basically said, DOJ, you've got pretty wide discretion to dismiss these cases, I think there's only been 2 C2A motions filed.
And I think generally folks don't believe that they're going to be successful. So
we'll see.
We'll see.
Hope springs eternal.
Okay, the next case is the SuperValu case.
Okay, so this is the other Supreme Court case that was decided last term. There's actually 2 companion cases with similar, if not virtually the same facts. US Ex-Rel Schutte v. SuperValu, the other is US Ex-Rel Proctor v. Safeway. And it's worth spending a moment on the facts for this case, because I think there's really useful parallels to a lot of scenarios that government contractors and vendors find themselves in contract and procurement contexts, where you have most favored nation or price matching type requirements. So this is a case involving pricing by pharmacies for dispensing drugs that are then reimbursed by federal health programs, and principally Medicare and Medicaid. And Medicare and Medicaid say that they will reimburse the quote-unquote usual and customary price of the drug. And what these cases were all about, and it's not just these 2 cases, this is a common case that was brought against virtually every pharmacy in the entire industry over the last 7 to 10 years, is what does usual and customary mean? And the reason why we had this industry sweep is a number of years ago, Walmart was getting into the pharmacy space, and to sort of promote its pharmacy business and get shoppers in the store to utilize its pharmacy, it introduced the $4 generic program. Anybody who's getting a generic drug dispensed has to pay no more than $4 no matter what the drug and no matter what your insurance coverage is. Every other pharmacy, just about, to keep up with that from a competitive standpoint, was trying to figure out how can we compete with that without turning that $4 price into our usual and customary price, which would cause them to lose money on dispensing other drugs. And what a lot of pharmacies, including Safeway and SuperValu, had a version of this, if I'm not getting those mixed up. What they did was they had sort of a price matching program if you were a member. So it's like a discount club membership. I think everybody has seen versions of these where some of them require a nominal membership fee, some of them require no fee, but you have to enroll and provide information, and and so on and so forth. You type your number in at the checkout. And the idea there was, if you're creating that kind of barrier to entry, so to speak, into the pricing, it's not your usual and customary price because it's not a price that is offered to the general public at large. But then, of course, the question is, do Medicare and Medicaid define usual and customary in a way that might nevertheless capture the discount club pricing? And so there have been a number of qui tams, a number of government suits that have been brought alleging that these pricing arrangements, if that $4 price isn't passed on to the government, is a fraud under the False Claims Act. And so the issue that arose in the SuperValu and Safeway cases is around knowledge. Did those defendants know that usual and customary meant their membership discount club pricing such that they were required to disclose those prices to the government? At the district court level, and then affirmed on appeal in the Seventh Circuit, the court ruled that because the defendants had proffered an objectively reasonable interpretation of the term usual and customary that excluded discount club pricing, and there was evidence for that. In fact, some states even define their usual and customary in guidance to exclude discount club pricing. But because they proffered an objectively reasonable interpretation that would have won the case for them, the case was not viable. And summary judgment was granted on that ground, notwithstanding that there was no evidence in the record that the defendants actually held that interpretation at the time of the false claims being alleged. So that was the issue that went up to the Supreme Court. Is that enough when you have an ambiguous legal requirement that is the predicate for falsity under the False Claims Act? If you proffer an objectively reasonable interpretation of that makes your claims not false, can you defeat the knowledge element regardless of whether you actually believed it at the time? And the Supreme Court, in a 9-0 opinion, said no. What matters is what you actually knew at the time, the defendant's subjective belief. It is not enough to show that the legal requirement in question was ambiguous and open to interpretation. And much like the court did in the Escobar case in 2015 when it was interpreting and providing guidance on how to evaluate the materiality requirement, Justice Thomas in Schuette said, to interpret the False Claims Act, we look to common law fraud principles because this is a statute that sounds in fraud. And under the common law, as the knowledge element is defined by statute, we look at what is reckless disregard and deliberate ignorance. And the common law instructs us that reckless disregard means when you are conscious of a substantial or an unjustifiable risk that a claim is false, but you submit the claim anyway. Or in the companion idea of deliberate ignorance, you are conscious of a substantial risk that your claims are false, but you blind yourself to the information that would allow you to confirm or rebut the falsity of your claims. And so the court reversed, notwithstanding that in addition to the Seventh Circuit, 4 other circuit courts had adopted this same idea that an objectively reasonable interpretation of an ambiguous regulatory requirement could defeat Sienter. So the Supreme Court really completely overturned what had been the trend in that regard and really put the emphasis on what is the evidence of the contemporaneous understanding of the defendant at the time of the alleged false claims. A number of questions kind of left open there. What is a substantial and unjustifiable risk is one, probably a fact-dependent question. Another is there any risk that could be so substantial and unjustifiable that it doesn't even matter if you were conscious of it? And then the last is, what about a legal representation? What about a representation of law? I represent to you that I am in compliance with X law. The Supreme Court said, we don't actually think that's what's going on with usual and customary, so we're not really reaching that question here, because really what you pharmacies are saying is my prices are usual and customary, which is a representation of fact. So why is this important? I think while the outcome in that case was not That's shocking, especially given the common law principles. I think there's potentially significant ramifications for how defendants approach these cases in litigation. First is on the motion to dismiss. It's already hard to win a motion to dismiss for failure to plead scienter. It doesn't have to be pled with particularity under Rule 9b like the other elements of a fraud claim do. And so the ability to get cases dismissed at that stage, at least on the knowledge element, is that much harder. It's potentially harder to get cases dismissed on at the summary judgment stage too, because now, arguably, the plaintiff can essentially point to competing interpretations of the same rule and say, I've created an issue of fact, and therefore this case should proceed to trial. And I think that raises another really, really important question, in my view, for corporate defendants, but both in terms of how DOJ evaluates these cases and evaluates knowledge, but also how a court would evaluate it, or finder of fact would evaluate in litigation, where you have companies with hundreds or thousands or tens of thousands of people whose interpretation matters. Is it the legal department? Is it the business who's most closely aligned with the false claims in question? Is it the compliance department? Is it the C-suite? If you have different people who have different views about what the law means, whose interpretation controls? That question is an open question. Another really difficult question is, as I think everybody in here is aware, very often our legal interpretation is going to be behind privilege, and it's going to be informed by the advice of counsel, whether internal or external. And so I think those things counsel in favor of, especially for contractors who have I think compared to other industries who are doing business with the government, typically a more open line of at least potential communication with their government partner, creating that contemporaneous record of what your interpretation of the legal rule, the ambiguous legal rule is. It invites the feedback as a practical matter, but it puts that marker in the ground. This is what we think the rule means at this point in time, so that the defendant can't be charged after the fact with, that is all a post hoc justification made up by smart lawyers in litigation, which was essentially how it was all framed in the Schuette case.
Just maybe something to add. Sure. I agree with you in terms of the ramifications of the decision. I mean, obviously, the Safeco defense, was it an objectively reasonable interpretation of an ambiguous contract term or regulation, was a helpful defense. I mean, I do think, and some of you in this room may have heard me say this before, the other side of the coin of this question is falsity. So under the False Claims Act, falsity is one of the three elements, and you are supposed, in order for the falsity to be of the type that could lend itself to an FCA violation, there has to be an objective falsity, something that is clear, like a right and a wrong. And I think it's kind of interspersed with this question of whether a regulation is ambiguous. And you heard it a little bit at the argument. I think it was Justice Kavanaugh said, well, we wouldn't really think about whether our interpretation was, I think, ambiguous or not. It was more like whether it was false or not. I'm mangling a little bit, but he was framing it in terms of a falsity question, and Schuette certainly leaves the kind of the objective falsity defense. It's very, very much still viable.
And it's too bad that this case is what went up, because falsity was not challenged, and I just can't imagine a worse set of facts for defendants to have this scienter go up to the Supreme Court. It's just, you could hear the disbelief in everyone's voices that this could not set out a False Claims Act violation.
Yeah, definitely bad facts make bad law, and this was not a great case. I mean, I think definitely in the government contract sphere, there's lots of ambiguous regulations, right? And there's lots of instances in which there is no kind of clear right or wrong. I think, you look this year, there was a big settlement I think it was Booz Allen, that for $377 million for, it was basically a case that involved indirect cost allocations, where there is no necessarily right or wrong way to allocate indirect costs. You need a reasonable method of allocation, but there can be multiple reasonable methods which all kind of yield a different proportional split between government and non-government work, for example. So,
I think that's a great example, but I think that's why it's so important now for, when you are, as a contractor, adopting one of those, multiple reasonable options on the menu, ensuring you have a really solid record of how you got to that point and why it's reasonable. But bigger challenge, doing it in a way that it is not hidden behind the privilege. And I don't think there's an easy answer to that, but it's something you would have to think about in advance.
Yeah, there's really not a lot of False Claims Act cases where someone waives privilege and it works.
Right.
It's just so hard to win a False Claims Act case based on the waiver of privilege. It's always not enough, not exactly on point, and then you've opened up this Pandora's box by doing so.
right. And of course, like what constitutes a reasonable interpretation, right? So if the management says, well, we think, or attorney, right, says, we think that, there's a 66% chance that a court would rule a different way than the way we're interpreting, is that per se unreasonable? I mean, it's 1 out of 3 chance you'd prevail, right? Well, what about 20%? Is it 10%? Is it 5%? Like, it's hard to figure out where to draw that line. So.
Right, then they always say, well, you should ask the agency, right? Get the agency's guidance. Can you get a response ever, first of all? And then secondly, it's always so qualified. This is, you can't rely on this, et cetera. So I think it's really challenging.
Or they'll just say, of course you can't do that.
But then you'd actually know. What's worse is, you proceed at your own peril.
Yeah, but the question is, who do you ask? I mean, if you ask a contracting officer, if you ask, 100 contracting officers, you may get different answers amongst all of them, right?
Fair.
So, okay. You bring the slides back up? Thanks. Okay, so I'm going to speed through these next slides because I think we're a little bit behind. So we included just one Rule 9b case, not because it is any sort of groundbreaking case, but just to use it as a means of highlighting that there still remains this circuit split about what is required to satisfy Rule 9b under the False Claims Act, right? So for those of you who don't know, Rule 9b requires that fraud be pled with particularity. And back, 30 years ago, right, it was quite clear. You had to allege the particulars, meaning the who, what, when, where, and how, right, of an actual false claims, of an actual false claim. And then the case law started to shift a bit, and it became a lot fuzzier and kind of depending on what circuit you were in. Some still required more or less that, you identify a particular false claim, like an invoice number, for example, et cetera. Others said, no, you don't actually have to do that. You just have to plead a fraudulent scheme with particularity. And some said, well, you just have to have kind of reasonable indicia reliable indicia of that fraud has occurred. And so this has been led, I think, to some forum shopping by relators. But it also has resulted in several cases going up to the Supreme Court, asking for the Supreme Court to resolve the split. In every instance, the Supreme Court has declined to resolve the split, and the Department of Justice has urged the Supreme Court not to take on these cases, arguing that, the case law is actually kind of coalescing around there not being kind of a rigid requirement to plead the particulars of a false claim. So I'm going to skip the... Well, I guess real quick, I'll just highlight what the Second Circuit said in this case, just to highlight kind of how messy it is. So this is a case in which the relator alleged that the defendant had engaged in several schemes to ensure that Medicare and Medicaid procedures were approved for payment and that they were medically necessary. The defendant in this case was a contractor, not an insurer or a provider, but instead had a contract to review claims to ensure that they were medically necessary. Instead of doing individualized kind of reviews, they were using essentially AI to determine whether or not claims were medically necessary. The relators didn't identify any particular claim that was wrong. They just said basically statistically, if you look at the percentage of claims that were being approved, it just can't be you're using kind of incorrect criteria and improperly doing this work. The second, the district court dismissed the case on Rule 9b and falsity grounds. The Second Circuit affirmed. And then on the one hand, in the decision states that the party alleging fraud, quote, must specify the statements that the plaintiff contends were fraudulent, identify the speaker, state where and when the statements were made, and explain why the statements were fraudulent. And then, 2 paragraphs later says, well, despite those generally rigid requirements, the allegations can be actually based on information and belief when the facts are peculiarly within the opposing party's knowledge. And in such cases, there just have to be facts supporting a strong inference of fraud. So it kind of was speaking out of both sides. And so we included a slide here that shows what the circuit split is. Even in the 11th Circuit, that generally is viewed as the most stringent of the circuits requiring specific details of false claims, there's a case that kind of said in dicta that no, maybe you don't. So we'll see whether or not the Supreme Court ever resolves this issue. I see some head shaking suggesting that you don't think they will. I don't think they will either.
They've had a lot of opportunities and passed.
All right. Next case we're going to talk about is the Care Alternatives case. This is a case that we're going to talk about in the context of Escobar, which you've heard us refer to. This is a case from 8 years ago. It's hard to believe that 8 years has passed since the Escobar ruling. For those of you who don't know, that was a case in which the Supreme Court validated the implied certification theory of liability, but also said that in such cases, the plaintiff or the relator has to satisfy the demanding and rigorous materiality and scienter requirements, and that not every violation of a federal payment condition is material for FCA liability purposes. This is a case that's been around for a while. It was first filed in 2008. There was a important Third Circuit decision in 2020 that is one of the cases that was the part of the circuit split that led to the SuperValu case. We're not going to talk about that. But in this more recent case, after the defendant was granted summary judgment again after remand from the Third Circuit, the defendant, and this is a case involving whether or not the defendant violated the False Claims Act by submitting claims to Medicare with inadequate documentation supporting the patient's eligibility for hospice care. And in this most recent kind of skirmish, the defendant argued successfully to the district court that whether or not they had adequate documentation wasn't material to the government's decision to pay. And the court agreed and said, well, the government can look and see that there wasn't such documentation. They paid anyway, so therefore it's not material. And the Third Circuit said, essentially, you can't put so much weight on that one factor. There's also a genuine issue about whether or not the government had actual knowledge about the inadequate documentation. And we should really just leave it for the jury to decide. So to Jonathan's point earlier, right, I think it's making it much more difficult to get rid of these cases at the summary judgment and motion to dismiss stages. So, any other commentary about Escobar?
I'll say on that point, if we don't have a DOJ member up here, but I have heard them vocalize many times that they feel very strongly that a case should not be dismissed based on the continued payment of invoices to an FCA defendant. And the example they use frequently is, something about supplies to troops, for example, or something that really, we actually need to get that product in the hands of troops overseas, et cetera. And if there's some sort of, even if they knowing non-compliance, they still need to pay that invoice and get that item to the troops, and that shouldn't mean that whatever the non-compliance is not material. So I think when you're making those arguments, which I think the Escobar materiality is still a very fertile ground for defending cases. I think coupling that type of argument with others is very important, and you can also expect perhaps DOJ to come in, which is something that if you're defending a non-intervened False Claims Act case, you want to think very carefully about trying to stave off that type of statement from the government against you, because that can be very persuasive to a judge.
But I do think in that hypothetical, right, that it is also very important to note whether or not the agency has, even if they're continuing to pay, complained about,
Yep.
right?
Objected.
Right, exactly.
Exactly, yeah.
So, okay. Next topic is cyber. So we've said for a number of years that cyber was going to be the next kind of hot area where we're going to see a ton of cases, and then I thought maybe I'd had egg on my face because, it was kind of slow going. But then we saw, the Marcus case, and now, the creation of the Civil Cyber Fraud Initiative in October of 2021. And we're going to talk a little bit about what we're seeing here. So
I won't go too far into this, because I know that we heard a lot about cyber from the prior panel. Just a few things that I wanted to highlight for this group on the Aerojet case that I don't think came up. So the relator here was a former insider. So he was the senior director of cybersecurity compliance and controls at the company. I think the evidence was that he had made internal reports and felt that the company wasn't appropriately responding to his concerns. So, that's just a lesson. I'm sure all of the folks from industry out here have good, whistleblower policies, but it just shows the importance and kind of delicate nature of being able to, try to respond to whistleblower concerns in a way that shows them that the company is taking things seriously, in a way that would hopefully give them comfort so they wouldn't go outside. This is a case that was actually filed before the initiative was announced in 21, so back in 2015. I remember when the district court denied the motion to dismiss, we were a little, I guess maybe not surprised, maybe a little disappointed, because this was a contract to provide mission defense and rocket engine technology. This was not a contract to provide cybersecurity services. Nevertheless, the district court said, well, this is important enough that we think that they've pled materiality and we'll let it go to discovery. In discovery, it turns out that I think one of Aerojet's defenses was, well, we were very open with our customers that we were not compliant with all of the cybersecurity regulations, requirements, et cetera. But when the case got to summary judgment, the court, it seems, really did kind of a side-by-side comparison. He took the company's internal audit reports, and then he looked if he could match those up with actual evidence of a disclosure. And unsurprisingly, there was not a complete match. And so the court said, the evidence looks like there was only partial disclosure, and I'm going to let it go to a jury. I think there was also evidence in the case that Aerojet was working on trying to get a waiver of certain of these requirements from its customers. So I think the facts were not terrible, which is maybe part of the reason that Aerojet actually went to trial. But then, as you heard from the earlier panel, they did settle on the second day of trial. Even though we have the Civil Cyber Fraud Initiative, we don't have a lot of comments from the government, formal comments from the government about how it's viewing these cases, because, as you heard earlier, they've all settled. But here, DOJ actually filed a statement of interest at the summary judgment phase, where they said, picking up on what Ann said, that materiality is not lacking merely because the government pays a claim with some knowledge of noncompliance. Again, there was a dispute about how much the government actually knew. And they also said, and this is interesting, false claims for payment for cybersecurity services that the company failed to provide as required can be a source of damages even if the contracted services were provided perfectly. So that raises a question, what are the damages, what will the damages theories in these cases be? As you saw from the earlier slide, so far the government hasn't recovered very much money from these cases. I think Verizon was $4 million, the other two were under $1 million. I can tell you I spoke on a panel with a relator's lawyer in January in New York, and she said, well, gosh, the damages are the full value of the contract. And then, of course, I get treble damages and penalties on top of it. Now, this person also had, I believe she said, 6 or 7 of these cyber FCA cases in the hopper. So I will agree with the earlier panel's comments that we are seeing more of these cases. In my practice, I think all of us are seeing more cyber FCA investigations. What we haven't seen yet is like a deluge of litigation or settlement. So we'll just have to kind of see what happens with the cases.
And I think some of the damages will stem from the theory. If the theory is you misled the government to get FedRAMP authorized, or at that threshold level, then every invoice is tainted. We never would have contracted with you, bought your product. If it's not there, but there was a POAM or there was something right down the line, and if we had known X, we would have required Y remediation. We didn't know X, we didn't require Y remediation, and then I would hope that then the damages would be what would they have paid, and something more like that. But I agree with you. I mean, I think that's the one kind of piece of solace I'm taking from some of these cases is that the damages don't seem to be off the charts. But of course, it's so hard to predict what type of negotiation, litigation risk, et cetera, that the parties applied.
Right. And I did forget to say, with respect to Sarah, I do disagree. I think it is, at least to some extent, about the money for the government when they're talking about these cases. Just one other thing I wanted to highlight on the slide is that we are also tracking a civil FCA case that was filed against Penn State. The allegations there, it's a relator suit, and the allegations relate to some research contracts that it had, I think with NASA, I'm not 100% sure. And the question was whether they had appropriate systems in place to handle CUI. It's kind of an interesting case where the district judge got a little antsy and unsealed the case before DOJ was ready to make its intervention decision. And so the court went ahead and unsealed the case. Penn State was served, and then it looks like the parties got together and then jointly went to the court and asked for a 6-month stay so that DOJ could complete its investigation. So I think the stay will expire sometime in the spring, so we'll see if DOJ is going to intervene, or as it has done, at least in the Aerojet case, decline. If we could go to the next slide.
I think it is, I'm sorry, one last thing.
Please.
So it is interesting, I think, like in the Marcus case and the Penn State case, right? The whistleblowers were both kind of like the cyber professionals within those organizations, insiders. I do, and some may have heard me say this before, I think that this is an area where it's kind of like that perfect storm for having a whistleblower who's like the cyber professional, right? Because the last thing they want to do is to have a breach on their watch. They want all the resources. They may not be kind of as attuned to the limitations and reasonableness of kind of the cyber-related budgets. And so you're going to have, I think, a lot of whistleblowers in this area.
And if we, thinking back to the Schuette case and what does it take for, in terms of a culpable, interpretation, for lack of a better word, I mean, we're seeing this, and it's not hard to imagine. You have somebody on the cyber team who says, in order to be compliant with NIST, we have to do X. And there's other people on the team who say, no, I think we're perfectly fine doing Y. And it turns out that the government partner prefers X. That's a recipe for a False Claims Act case right there. Even though you believed in good faith, Y was perfectly compliant with NIST or other contractual standards. I mean, that's like the paradigm of the case that we're starting to see in these cyber scenarios.
Yeah. And a lack of understanding about what NIST requires and doesn't require, that it's not kind of a black and white, it's have this policy, abide by this policy.
And we don't need to go into the nitty-gritty on CMMC because we heard about it from the earlier panel, but I would just flag, my antenna went up when they talked about the annual affirmations that are now going to be required. We also heard about representations that will need to be made. So in addition to concerns about regular, non-compliance with requirements, and are we going to have a relator or DOJ take the position that it rises to a level of fraud, we also now have these additional representations and affirmations that we're going to have to be making that can also give rise to potential claims. So just to kind of wrap up, what are the risks given everything that we've heard? In addition to certifications and affirmations, contract terms, flow downs, we need to make sure that we know what the requirements actually are. System boundaries for CUI. I've got some clients that, part of their NIST compliance plan is that CUI will only be handled on certain information systems. Need to make sure that everybody's aware of which information systems are compliant and which ones are not. SPRS reporting, so of your score and your POEM date. I've found that there has been some, kind of confusion given that the rules have been changing. Cybersecurity compliance requires both an IT and a compliance focus and expertise. So obviously, there needs to be this important partnering between compliance professionals in terms of what the requirements are, the ever-changing requirements, as we've heard today. And of course, then they need to work with IT to actually, implement the changes. Another kind of risk area that we've seen in some of our cases is the differences between documentation and implementation on the NIST standards. I think someone talked about that earlier. I had one client that thought that they were in much better shape than they were, and it turns out that they were in great shape from an implementation standpoint, but the documentation was a little bit lacking. And then the last point is just as everyone in this room knows, the rules continue to evolve, and so it's just important to stay focused and continue to be, aware and agile.
So in terms of DOJ enforcement priorities, we talked about cyber, we talked about some other areas. There's still a big focus on antitrust bid rigging. The procurement collusion strike force is alive and well. I think they, to my knowledge, are the only kind of initiative task force at DOJ that has a full-time director. Are you all aware of any others that have a full-time director? No? He goes out on speaking tours and touts their statistics. So they're relatively impressive. They've had over 100 investigations open. They have, I think, over 50 pleas or indictments. And I know in some of our matters, we've seen some matters that have started out as your more plain vanilla procurement fraud cases that have kind of morphed into criminal matters with bid rigging allegations. So certainly an area where there's a lot of parallel enforcement activities.
Just touch on another area that we saw a lot of case law activity this past year, and that is the issue that comes up in kickback cases of when a claim has resulted from a kickback, and I'll cover this briefly, and then we have one more topic to end on here. So the current state of play for many years, from 18 until 22 here, was a very plaintiff-friendly interpretation by the Third Circuit, which rejected any sort of but-for causation requirement between the claim and the kickback, and basically said that if you have the allegation that a kickback was paid, and then there's any sort of federal claim that gets submitted by that entity, that is enough to have the sufficient link between the kickback and the claim.
And this, I'm sorry, and this is the healthcare related anti-kickback statute, not the kickback in the procurement fraud context.
Right. So the wording here in this statute is the AKS statute as amended in 2010. And that says that a claim that includes items or services resulting from, and that is the phrase that has this very divergent interpretation by courts right now, of a kickback constitutes a false or fraudulent claim. This is one of the most common bases for False Claims Act cases, because the relators and the government take the position that this language here in this first bullet means that a kickback violation is a per se False Claims Act violation. And you have these large damages amounts, so this is probably the most common theory that we see in the False Claims Act world. In 2022, though, the Eighth Circuit took a different view and said no, resulting from requires but-for causation. You have to be able to plead and then prove that the claim would not have been submitted but for the kickback that was paid. Next slide. We can go through these a little bit quickly, but then the widening split that happened this year was the Sixth Circuit took the Eighth Circuit side and said but for causation, this narrower interpretation is the right one. And then in an interesting turn here, in the same district court, the District Court of Massachusetts, within 2 months, the court ruled differently on this same issue. So in the Regeneron case, and this was an intervened case by the government, the court sided on the side of the Sixth Circuit and Eighth Circuit and said but-for causation was required. The court recognized that they were diverging from prior First Circuit cases on this issue, which had followed the Third Circuit. And so that ruling was certified for interlocutory appeal, and the government's brief as the appellant is due in March. And then in the next case, also in the District of Massachusetts, in the Teva case, that is a government, not even a relator involved, government case. It actually involves the same underlying issue, which is the payment of co-payments of patients through charity. And there, the district court judge ruled the opposite and said but-for causation is not required. That case is also up for appeal. There's a motion, perhaps not surprisingly, to combine the cases on appeal that hasn't been granted yet. So that case is starting its briefing with the defendant going first as the appellant in February. So we will see the First Circuit weigh in on this issue sometime in the near future. And the last slide just summarizes kind of where we are. I think this is an interesting issue for, False Claims Act geeks, because it's just another good example of why the forum is so important. And it's really, if you are facing a False Claims Act case, understanding the law in your circuit is hugely important, because it varies considerably until the Supreme Court weighs in.
And it seems almost a sure thing that the Supreme Court will take this up at some point, maybe even in the Teva case, where you have not only a circuit split, but you have within that case a district court split. But what I think will be very interesting to see is, we had 8 years ago a Supreme Court articulation of False Claims Act materiality, referring to common law principles to interpret what that means. We just this term had a Supreme Court case interpreting the FCA's knowledge element and applying common law fraud principles to what that means. It's not hard to see this case, Teva or another case like it going up, and Justice Thomas writing another opinion saying, I've said this twice already, we look to the common law principles of fraud to understand what causation means. That is but for causation, maybe combined with proximate cause. And so that has, potentially huge ramifications outside of the healthcare case, where, it would be a principle that would apply to subcontractor cases. What does it mean to cause a prime contractor to submit false claims, for example? And it would be really important for loss causation theories, especially in the kinds of cases we've already touched on, where the false claim, is some legal harm, but not an actual harm in terms of, paying for something that wasn't provided, or causing some kind of expenditure of money the government wouldn't otherwise have had to spend. So I hope they do take it up. It'd be really interesting, not only from the healthcare standpoint, but to get that articulation of causation.
Yeah, I agree with that. I think especially on that last point, right? So if you look at the issue in the AKS context, the issue is really around the 2010 amendment language of results from, right? And the courts have debated what the causal connection is there. But on the damages context, right, the False Claims Act says that what's trebled are the damages that the government sustains because of, right, the alleged false claim or statement. And to me, that because of is really kind of analogous to the results from language in the AKS. So.
Okay, last topic.
Yep.
So last topic here is the DOJ compliance program and cooperation credit guidance. So this is a very practical consideration if you are facing a False Claims Act suit, especially if your facts are not great, is how do you handle the CID? How do you handle the investigation in a way that is most beneficial to resolving the case? In May 2019, DOJ formalized its guidance for how FCA defendants can earn cooperation. They then folded that guidance into the Justice Manual at 4-4.112, and there are some details in the guidance, but it's pretty high level. They note that there's 3 different ways that an FCA defendant can earn cooperation credit: through a voluntary disclosure, cooperation, and putting in remedial measures to address the issue. They also elaborate as to what does not qualify for credit. So just responding to the CID does not qualify for credit. Making a mandatory disclosure, a lot of people are probably familiar with their mandatory disclosure obligations under 52203-13, that does not qualify to DOJ as cooperation. It really has to be above and beyond. Past those types of details, though, there's not a lot of concrete guidance as to what the carrot is for cooperating. And when this guidance came out, it was in stark contrast to some guidance on cooperation that had come out the year before in the FCPA context, which you might hear about more tomorrow. But there, not to get too far into the weeds, but for example, you can get, if you cooperate, a recommendation by DOJ that fines will be at 50% of the low end in the sentencing guidelines. Very concrete, you can get a declination, concrete rewards for cooperation. And in the False Claims Act world, it's kind of anything but. Until recently, we've got a few settlements, but it's pretty hard to figure out and advise your client or advise people at your company as to what exactly the reward will be for this type of cooperation. Recently, what we wanted to highlight today is that in 2023, and even as recently as last week, there have been some FCA settlement agreements that have recognized and stated that the defendant has received cooperation credit in resolving the case. They then, in some cases, it varies widely, describe the type of cooperation that was provided, and that's what you have on this slide with Vital Access and Verizon. They do not spell out still what exactly was given to the defendant in exchange for this cooperation. They do not say, absent the cooperation, we would have pursued X amount of money, and instead we resolve for Y amount of money. What we're trying to do here with these multiplier numbers is glean what might have been obtained by this cooperation. Typically, this is not an actual explicit written policy by DOJ, but typically if you settle a False Claims Act suit, the multiplier, you've been hearing us say treble damages, but the multiplier is usually somewhere around 2. And so when we see a settlement that is sub 2, we oftentimes wonder or can assume that perhaps it's because of some sort of cooperation credit. So that's what we see here, and just in the next slide as well, we saw 2 more examples. I'll note that last week, Moffitt Cancer Center agreed to a $19.5 million settlement, which is not up here because it just happened last week, and they resolved for a 1.5 multiplier, so that's another example. The problem with all of this is, as you heard me say, it's just not clear. And multipliers generally are informed by a multitude of factors. It's oftentimes how bad the facts are or how bad DOJ perceives the defendant's scienter to be. So I've had cases where we cooperate and DOJ thanks us profusely for our cooperation, but we don't get a multiplier that would stand out because there's countervailing considerations. And the last thing about this that makes it so fuzzy and difficult to have any sort of sense of how something is going to go in this area is I find it varies a lot based on who the DOJ attorney is. A lot of times you're dealing with the U.S. Attorney's Office and not Main Justice. That can vary a lot. And even within a U.S. Attorney's Office or civil frauds in Main Justice, who the line attorney is can really influence their appetite for lowering the multiplier for any reason whatsoever, including cooperation. I'm sure you all have similar or not dissimilar experiences.
I think, one thing that's important to keep in mind is what are we multiplying and
Yes.
Even in cases where we, the cooperation isn't so exemplary that we can get a reduced multiplier, we can often, there's kind of two sides of the same coin. If you can reduce your single damages by half, you're essentially achieving, something similar, so.
Really? Well, unfortunately, I think we're a minute past our time, so we're gonna wrap up now, unless we get more grace. Sounds like no. Thank you all.
Thanks, everyone. We have Ann Robinson from Latham and Watkins here today, joining us for the recorded presentation. Ann's available to answer any questions you might have. Please drop those into the Q&A box if you'd like, and we'll give you a couple minutes to think about that and give Ann some food for thought.
Okay, sorry, I was having some technical difficulties. This is Ann. Thank you for the question. So the first question I see is about Senator Grassley's updates to the FCA. His most recent proposals generally involve changes to the materiality element in light of the Escobar opinion. He is basically suggesting kind of a burden shifting regime where if the defendants had a materiality challenge, they would basically have the burden to show that the allegation was immaterial, which is different than how the statute is currently structured. That's what he's mainly focused on recently. So the second question, just if everyone, I don't know if everyone can see it, but it says contracting officers are required to refer claims involving suspected misrepresentation of fact or fraud, but boards of contract appeals use a mere suspicion legal standard for taking jurisdiction. Any thoughts on concurrent board litigation and DOJ False Claims Act investigations? So this is a great question, and it's an interesting one kind of procedurally and subject matter wise. a lot of times when you're facing a False Claims Act litigation, there is a very complicated question that involves deep government contracts expertise. And sometimes the whistleblower doesn't understand, or maybe their attorneys don't quite understand all the nuances. And it can be helpful to kind of go on the affirmative, if you will, and try to get a tribunal, maybe not the tribunal where the False Claims Act case is pending, to opine on the disputed government contracts issue. So one of the venues for doing that, there's only certain venues that have jurisdiction, is the Board of Contract Appeals. What we've found is that sometimes that works, meaning they will hear the question. Sometimes it doesn't, because if there is a pending False Claims Act case, sometimes the Board of Contract Appeals will not want to opine if the issues they feel are overlapping under the doctrine of comity. They want the first tribunal to first pronounce on what the issue is, even though they don't necessarily have the same expertise as the Board of Contract Appeals. So it's something to think about and to consider whether filing an action in a Board of Contract Appeals might be beneficial to you. And also you might have to convince that tribunal that the issues actually don't overlap, because of course it is a different inquiry. You're asking probably for contract interpretation versus a fraud claim, which again, the underlying non-compliance, one piece of it might be the same, but the inquiry is different. And so there's a kind of well-known kind of long-running case that went up and down a few times where the defendant did actually get a very helpful decision from the Board of Contract Appeals, which then helped with the False Claims Act case. Those are the only two questions I see. I'll give just a few more seconds here. Okay, Bill, I'm not seeing any other
Yeah, it looks like, yeah, that's fine. Thank you, everyone, for those questions. It's really appreciated. And Anne, thank you for joining us today for the Q&A. And of course, thank you to you, Andy, Tirza, and Jonathan for all your efforts for the presentation at our live event in February. We really appreciate you. Couldn't do it without you. So thank you, and thank you to our attendees. We're going to play a short video, and then we'll give everybody a few minutes back in their day. Thanks.
Great. Thanks, everybody.
Thank you for joining us today. And thank you to our panelists for their presentations and live Q&A. And again, special thanks to our sponsors whose support made this event possible.